In episode 19 of the Supreme Court Opinions Read podcast, I'll be reading the Supreme Court's opinion in a case versus Montana. The case was decided January 4th, 2026. And as always, we'll start with the syllabus. In Brigham City v. Stewart, the court held that the Fourth Amendment allows police officers to enter a home without a warrant if they have an objectively reasonable basis for believing that someone inside needs emergency assistance. In this case, Montana police officers responded to the home of petitioner William Case after his ex-girlfriend called 911 to report that he was threatening suicide and may have shot himself. The officers knocked on the doors and yelled into an open window but got no response. They could see an empty handgun holster and something that looked like a suicide note inside, and they ultimately decided to enter the home to render emergency aid. When one officer approached a bedroom closet in which Case was hiding, Case threw open the closet curtain while holding an object that looked like a gun. Fearing that he was about to be shot, the officer shot and injured Case. An ambulance was called to take Case to the hospital, and officers found a handgun next to where Case had stood. Case was charged with assaulting a police officer. Case moved to suppress all evidence obtained from the home entry, arguing that the police violated the Fourth Amendment by entering without a warrant. The trial court denied the motion, and a jury found Case guilty. A divided Montana Supreme Court upheld the officer's entry as lawful under Montana's caretaker doctrine, rejecting the contention that an officer must have probable cause to believe that an occupant needs emergency aid. Held. Brigham City's objective reasonableness standard for warrantless home entries to render emergency aid applies without further gloss and was satisfied in this case. Part A. Searches and seizures inside a home without a warrant are presumptively unreasonable under the Fourth Amendment, but the warrant requirement is subject to certain exceptions, including the need to render emergency assistance. The court first approved a warrantless home entry to render emergency assistance in Brigham City, holding that officers may enter when they have an objectively reasonable basis for believing that an occupant is seriously injured or imminently threatened with such injury. The Montana Supreme Court's opinion below strayed from that rule. Most important, the emergency aid test incorporated in Montana's caretaker doctrine evokes the Fourth Amendment standard of reasonable suspicion that applies to relatively non-invasive street stops, but Brigham City adopted a different standard for home entries. Case now urges the court to understand Brigham City as sounding in probable cause, but the court declines to put a new probable cause spin onto the emergency aid standard. Probable cause is peculiarly related to criminal investigations, and that body of law would fit awkwardly, if at all, in the non-criminal, non-investigatory setting at issue here. Rather than strain to relate probable cause decisions to emergency aid situations, Brigham City asked simply whether an officer had an objectively reasonable basis for believing that entry was directly needed to prevent or deal with serious harm. Courts should assess the reasonableness of an emergency aid entry on its own terms, rather than through the lens generally used to consider investigative activity. Part B. The officers here had an objectively reasonable basis for believing that their entry was needed to prevent Case from ending his life. The information the officers obtained from Case's ex-girlfriend, combined with their observations at the scene, suggest that Case may already have shot himself or would do so absent intervention. The officer's decision to enter his home to prevent that result was reasonable. Accordingly, the court affirms the judgment, even though not all the reasoning, of the Montana Supreme Court. Justice Kagan delivered the opinion for a unanimous court. In Brigham City v. Stewart, this court held that police officers may enter a home without a warrant if they have an objectively reasonable basis for believing that someone inside needs emergency assistance. The question presented is whether that standard means that officers must have probable cause for the intrusion, as they typically would when investigating a crime. We hold it does not. The probable cause requirement is rooted in and derives its meaning from the criminal context, and we decline to transplant it into this different one. Brigham City's reasonableness standard means just what it says, with no further gloss. And here it was satisfied because the police had an objectively reasonable basis for believing that a homeowner intended to take his own life and indeed may already have shot himself. Part 1. This case began with an alarming phone call from petitioner William Case to his ex-girlfriend J.H., both residents of a small town in Montana. Case told J.H. on the call that he was going to kill himself. Because Case sounded erratic, J.H. assumed he had been drinking. She tried to talk Case out of committing suicide but couldn't reel him back. With each passing moment, Case became more methodical about what he was going to do. Case said that he was going to get a note, presumably meaning a suicide note, for J.H. or others to find, and then J.H. heard a clicking sound like the cocking of a gun. J.H. told Case she was going to call the police, but that seemed only to antagonize him. Case replied he would shoot them all too. Finally, J.H. heard a pop followed by nothing, just dead air. She yelled Case's name a few times but got no response, leading her to think he had pulled the trigger. So she called 911 to report the incident and drove as fast as she could to Case's home. 3 police officers dispatched to do a welfare check on a suicidal male met J.H. outside the house. They decided the situation was very serious based on both what J.H. told them about the call and what they already knew about Case. The officers were aware that Case had a history of alcohol abuse and mental health issues, that he had previously threatened suicide at the school where he worked, and that he had once seemed to attempt suicide by cop by confronting the police in a way that was likely to provoke a lethal response. So the 3 officers requested that the chief of police come to the scene. While waiting for him, they circled the house looking for signs of injury or danger. They knocked on the doors and yelled into an open window but got no response. Shining their flashlights inside, they could make out empty beer cans, an empty handgun holster, and a notepad with writing on it, which they took to be the suicide note Case had mentioned to J.H. At that point, however, they saw no sign of Case. Once the chief came, the officers conferred and decided to enter the house to render emergency aid. In the best-case scenario, they hoped to talk Case down and prevent any injury. But given J.H.'s account, the officers considered as well another possibility, that Case had already shot himself and might be in there bleeding. At the same time, they worried that if Case remained unharmed, their entry could spark a confrontation, so they equipped themselves with long-barreled guns and a ballistic shield before going in. The officers entered the house through the front door about 40 minutes after they first arrived. They announced themselves loudly and continued to call out as they walked through the home. Case did not answer. He was hiding in the closet of a bedroom upstairs. When one of the officers entered that room, Case threw open the closet curtain and appeared from behind it holding a black object which looked like a gun. Fearing that he was about to be shot, the officer fired his own rifle. The bullet hit Case in the abdomen, and another officer rushed to administer first aid. An ambulance was called to take Case to the nearest hospital, where he recovered. Meanwhile, one of the officers found a handgun in a laundry basket next to the place where Case had stood. The county attorney charged Case with assaulting a police officer. Case moved to suppress all evidence obtained as a result of the home entry, arguing that the police had violated the Fourth Amendment by coming into his house without a warrant. The trial court denied the motion on the ground that the police officers were responding legitimately to an emergency. A Montana jury then found Case guilty of the crime charged. On appeal, a divided Montana Supreme Court upheld the trial court's ruling that the officer's entry was lawful. The majority analyzed the issue under its community caretaker doctrine. It noted that a recent Fourth Amendment decision of this court, Coniglia v. Strom, had rejected a community caretaking rule allowing a warrantless home entry even absent a need to render emergency assistance to an occupant. But the Montana court thought its community caretaker doctrine survived that holding because it demanded such an emergency. Under that doctrine, the court explained, police could enter a home to do a welfare check only when objective, specific, and articulable facts would lead an experienced officer to suspect that a person inside is in need of help or is in peril. And the court found that facts meeting that description existed here because of the likelihood of suicide. The court rejected Case's alternative standard that a police officer must have probable cause to believe the occupant is in need of emergency aid. The probable cause locution the court suggested applies only when the police are engaged in a criminal investigation. The dissenting justices, by contrast, favored the proposed probable cause rule, which they concluded the officers here did not satisfy. In the dissent's view, the court's different approach resembled the mere reasonable suspicion standard applicable to comparatively non-invasive street stops. That standard, the dissent thought, was too easily met to support a warrantless entry into a home. We granted certiorari because courts have differed on whether police officers entering a home to provide emergency aid need probable cause to believe that an occupant is in peril. Footnote 1. This is just a citation to a bunch of lower court decisions going both ways on the issue, so I'm not going to read them all out. Carrying on. We conclude that standard borrowed from the criminal context is inapt. We instead hold just what we have held before, that the officers may enter if, but only if, they have an objectively reasonable basis for believing that an occupant faces serious danger. Part 2. The Fourth Amendment provides that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. At the very core of this guarantee, as this court has often stated, stands the right of a man to retreat into his own home and there be free from unreasonable government intrusion. When the intrusion is into that most private place, reasonableness usually means having a warrant. But not always. The warrant requirement is subject to certain exceptions, and among those is one pertinent here, involving the need to provide an occupant with emergency aid. This court first approved a warrantless home entry to render emergency assistance in Brigham City. There, police officers responding to a noise complaint observed through a kitchen window a physical altercation between an adolescent and several adults. As they watched, the teenager punched one of the adults in the face, sending him to the sink spitting blood. The officers immediately entered the home through a nearby screen door and, announcing their presence, caused the fight to cease. We unanimously approved the warrantless entry as reasonable under the circumstances, and we explained what made it so. The officers had an objectively reasonable basis for believing that an occupant was seriously injured or imminently threatened with such injury. 3 years later, in Michigan v. Fisher, we reiterated what we had said in Brigham City about the emergency aid exception. The police in Fisher, also responding to a neighbor's report, found a scene redolent of violence and danger. 3 windows were broken, with the glass strewn on the ground outside. Blood was smeared on one of the doors, as well as on the smashed-in hood of a pickup truck in the driveway, and, visible through a window, a man inside the house was screaming and throwing things at an unseen target. We held that the officer's entry in those circumstances was reasonable under the Fourth Amendment, just as it had been in Brigham City. Using the same standard articulated there, we concluded that the officers had an objectively reasonable basis for believing that an occupant of the home needed immediate aid. Finally, in Coniglia, we reaffirmed Brigham City, even as we rejected a broader community caretaking justification for warrantless home entries. The police had gone to Edward Coniglia's home after his wife reported that he was suicidal. Coniglia spoke with the officers on his front porch and agreed to go to a hospital for psychiatric testing. Then, once he had left, the officers went inside and took away 2 handguns he owned. The lower courts approved the entry on the ground that the officers were performing community caretaking functions, but we declined to recognize such an open-ended license for law enforcement officers to enter private homes. Citing Brigham City, we readily acknowledged that officers may enter a home to render emergency assistance to an injured occupant or to protect an occupant from imminent injury. But such emergency conditions were indeed necessary and, given the facts, officers had never tried to defend their entry on that basis. The Montana Supreme Court's opinion strayed from the Fourth Amendment rule that trio of decisions sets out. To begin with, the court's use of community caretaker doctrine was ill-advised given that Coniglia contrasted community caretaking with rendering emergency assistance and concluded that the former cannot alone justify a warrantless home entry. The Montana court, to be sure, tried to reconcile its approach with Coniglia by depicting its community caretaker rule as allowing home entries only in emergencies, but using terminology that this court has held misplaced in home entry cases could serve only to confuse the issue. And yet more fundamental, the emergency aid test incorporated in Montana's caretaker doctrine is different from the one adopted in Brigham City. As noted above, Montana's test finds a home entry reasonable when an officer has specific and articulable facts from which to suspect that someone needs help. That test's language, as the dissenting justices noted, evokes the Fourth Amendment standard applying to brief investigative street stops, reasonable suspicion based on specific and articulable facts. But Brigham City did not adopt Terry's reasonable suspicion standard for home entries, as both the state of Montana and the United States as amicus curiae acknowledge. Rather, Brigham City formulated its own standard for dealing with household emergencies. Again, whether an officer has an objectively reasonable basis for believing that an occupant is seriously injured or imminently threatened with such harm. Case, however, wants something more. He recognizes that the Brigham City test applies here and that it has had but one formulation. In describing and applying that standard, we have never used any different terms. But still, Case urges us now to understand the Brigham City test as sounding in probable cause. What the test really requires, Case contends, is that police officers have probable cause to believe that an occupant is seriously injured or imminently threatened with such injury. Case reaches that conclusion based mainly on the Fourth Amendment's recognition of the sanctity of the home. Given that special status, he argues a home entry's aid-giving, non-investigatory purpose should make no difference. The same probable cause principles used in deciding whether criminal activity is afoot should apply as well in assessing the risk and gravity of an emergency. We decline Case's invitation to put a new probable cause spin onto Brigham City. The probable cause standard, this court has often stated, is peculiarly related to criminal investigations. And the standard has acquired meaning over time by virtue of that context, as judges have assessed, in case after case, the requisite likelihood of finding criminal contraband or evidence. The resulting body of law would fit awkwardly, if at all, in the non-criminal, non-investigatory setting at issue here, so Brigham City adopted a different approach. Rather than strain to relate probable cause decisions to emergency aid situations, we asked simply whether an officer had an objectively reasonable basis for believing that his entry was directly needed to prevent or deal with serious harm. In adhering to that question, we respect, as ever, the first among equals status the Fourth Amendment affords the home. And in that vein, we note that an emergency aid entry provides no basis to search the premises beyond what is reasonably needed to deal with the emergency while maintaining the officer's safety. But we assess the reasonableness of that limited entry on its own terms rather than through the lens generally used to consider investigative activity. Doing so here yields a ready conclusion. The officers had, as Brigham City requires, an objectively reasonable basis for believing that their intervention was necessary to prevent serious harm. The officers had, as Brigham City requires, an objectively reasonable basis for believing that their intervention was needed to prevent serious harm. As earlier described, the officers knew firsthand that Case suffered from mental health and alcohol abuse problems, and that he had previously talked about committing suicide. When they reached Case's house, they learned about J.H. and Case's just concluded phone call, that Case, in an apparently inebriated state, threatened to kill himself, spoke of preparing a suicide note, and quite possibly cocked or even shot a gun before the line went dead. The concerns that call raised were heightened by what the officers could see through the windows, empty beer cans, an empty holster, and a notepad, as well as by Case's failure to respond to their urgent knocking. If Case had already shot himself, he could have been severely injured and in need of immediate medical care. And if he had not, the risk of suicide remained acute, given all the facts then known to the officers. It was thus objectively reasonable for the police to believe that Case needed emergency aid. Case counters that only the police entry itself created a likely danger. His argument turns on the prospect of suicide by cop. As noted earlier, Case had once before acted in a way seemingly designed to provoke a lethal police response, as the officers knew. And J.H. told the officers that Case had threatened to shoot them all too if they came to the scene. So the main risk the officers objectively faced, Case posits, was that their very entry would induce a shootout leading to suicide by cop. And indeed, Case contends the officers knew that. Why else would they have waited roughly 40 minutes after their arrival before entering his home? Case concludes that if the officers had only left well enough alone, nothing would have happened. But Case much oversimplifies a complex situation. the objective reasonableness of an officer's conduct under Brigham City, as in other Fourth Amendment contexts, is evaluated by looking at the totality of the circumstances. One of those circumstances was no doubt that Case could provoke a confrontation. As noted earlier, that was partly why the officers called the police chief to the scene and why they carefully considered protective measures, leading to some delay in their entry. But there is no basis for thinking that the officers would have gone into Case's home just so he could instigate a gunfight. The circumstances making their entry reasonable, as just stated, were those suggesting that Case may already have shot himself or would do so absent intervention. The statements Case made to J.H., plus the visual evidence corroborating them, indicated that Case wanted to end his life. The decision of the officers to enter his home to prevent that result, even at some significant risk to themselves, was at the least reasonable. The Fourth Amendment did not require them, as Case now argues, to leave him to his fate. We repeat today what we have said before. An officer may enter a home without a warrant if he has an objectively reasonable basis for believing that an occupant is seriously injured or imminently threatened with such injury. The officer's entry satisfied that test. Accordingly, we affirm the judgment, even though not all the reasoning, of the Montana Supreme Court. It is so ordered. Justice Sotomayor concurring. I join the court's opinion, which holds that police officers may enter a home without a warrant if they have an objectively reasonable basis for believing that occupant is seriously injured or imminently threatened with such harm. Although the Montana Supreme Court's opinion appeared erroneously to apply a lower standard akin to reasonable suspicion, I agree that the officers here had an objectively reasonable basis for believing that Case needed emergency assistance because he may have already shot himself or was imminently going to do so. I write separately to underscore the unique considerations that law enforcement and courts should bear in mind when assessing whether there is an objectively reasonable basis to believe that a person experiencing a mental health crisis needs law enforcement to render emergency assistance. As Brigham City explained, the justification for what would be otherwise an illegal warrantless entry of a home in this context is the need to protect or preserve life or avoid serious injury. The officers in Brigham City, for instance, needed to enter the house to break up an ongoing fight to protect a person whom they saw through a window being struck in the face and to prevent further violence. When an officer is called to respond to a person at risk of suicide, however, entering the house may not always be the objectively reasonable course of action to preserve life or avoid serious injury. In these kinds of circumstances, the presence of law enforcement at times can escalate the situation rather than ameliorate it, putting both the occupant and the officers in danger. The risk of escalation is also heightened by the prevalence of firearms in nearly half of American households. Footnote 1. In 2025, 42% of Americans reported living in a gun-owning household. Carrying on. Police may employ more forceful tactics when they know a firearm is in the house, and an occupant who is experiencing an acute mental health crisis may react more unpredictably in response. Studies show that individuals with serious mental health conditions are disproportionately likely to be injured and 7 times more likely to be killed during police interactions compared to the general population. Footnote 2. This is just a citation to studies showing as much, so I'm not going to read them out. Carrying on. One report showed that over a 2-year period, calls for help resulted in law enforcement officers shooting and killing the very people they were called to assist in 178 cases. Footnote 3. It's just another citation, so I'm not going to read it out. Carrying on. Another study found that police shooting incidents involving behavioral health concerns, suicidal behavior, substance use, or serious mental illness were 2.1 times more likely to result in fatal injury than other police shooting incidents. Footnote 4. Again, just another citation, so I'm not going to read it out. Carrying on. Further, individuals with a mental illness were 2.8 times more likely to be killed in their own homes compared to those without a mental illness. Footnote 5, another citation. Carrying on. Given these risks, in some circumstances it may be more reasonable for officers to try different means of de-escalation before entering the home of a person experiencing a mental health crisis. Officers should, for example, attempt to speak with the occupant from a distance or over the phone, contact family, friends, or neighbors to help intervene, Call in specialized police units such as negotiators or officers trained in crisis intervention, or otherwise work with mental health professionals to approach the occupant. Footnote 6. This is just a citation describing programs that involve sending teams of specially trained police to respond to calls about mental health crises. I'm not going to read it out. Carrying on. Footnote 7. Many jurisdictions around the country have introduced programs in which police officers and mental health professionals jointly respond to calls about mental health crises. Carrying on. Officers called to respond to these kinds of situations should carefully investigate and assess the nature of the potential crisis and determine whether there is an objectively reasonable basis to believe that the occupant needs emergency aid inside before entering without a warrant. Once the decision is made to enter, moreover, the manner of the officer's entry and their subsequent conduct inside must also be reasonable. This case highlights the very complexities that will often attend emergency aid interventions involving reported mental health crises. Multiple facts suggested that Case did not need emergency aid but was instead waiting inside for the officers in order to provoke a confrontation that would result in suicide by cop. Case had told his girlfriend, J.H., on the phone that he would shoot them all if she called the police to his house. Once J.H. arrived at the house, she told the officers that Case threatened to shoot it out with the police. The officers also knew that in a prior incident in which police were called to respond to a suicide attempt by Case, Case had confronted the police in a way that suggested he was attempting suicide by cop. Then, while surveying the house, the officers discussed how Case had tried suicide by cop before, and that it was likely Case was going to pull a gun on us once they go in the house. These facts, taken together, suggested that Case was neither already injured nor about to injure himself, but rather that the primary danger he faced would arise only if the officers entered his house. In other words, these facts tended to undermine the officer's basis to believe that he needed emergency assistance inside. The officer's warrantless entry ultimately did not violate the Fourth Amendment, however, because there were sufficient facts on the other side of the ledger supporting an objectively reasonable basis to believe that Case had shot himself. Critically, Case had told J.H. that he had a loaded gun, and J.H. heard a clicking sound like the cocking of a gun and a pop, and then just dead air, despite J.H. yelling Case's name multiple times over the phone. Case also told J.H. that he was going to get a note and kill himself. When the officers arrived, they saw an empty handgun holster and notepad with writing inside Case's house. And Case did not respond when they shouted his name into an open window. Considered together, these facts give rise to an objectively reasonable basis for the officers to believe that Case was already injured and in need of emergency medical assistance, and was not necessarily waiting inside for the officers seeking to provoke an escalation leading to suicide by cop. As a result, the officers did not violate the Fourth Amendment when they entered Case's home. Footnote 8. Case has not challenged the reasonableness of the officers' manner of entry or their conduct inside his house after entry. As a result, neither the decision below nor this court had occasion to consider the reasonableness of that conduct. Carrying on. That conclusion on the facts of this case does not mean it will always be objectively reasonable for officers responding to a mental health crisis to make a warrantless entry. A different mix of information might have led to the conclusion that the officer's entry itself would put the occupant and officers at greater risk of escalation and serious injury. Because the objectively reasonable basis test, as reaffirmed by the court today, demands careful attention to case-specific risks that attend mental health crises and requires officers to act reasonably in response, I join the court's opinion in full. Justice Gorsuch concurring. Today's case, like another before it, holds that police officers generally do not violate a person's Fourth Amendment rights when they enter his house without a warrant, but with an objectively reasonable basis for believing someone inside is in physical danger and in need of immediate aid. Importantly, the court observes this exception to the warrant requirement permits entry only to the extent reasonably necessary to address the apparent emergency and does not authorize officers to search a home more broadly. With all that, I agree, but to me a question lingers. Why? Does the Fourth Amendment tolerate this limited emergency aid exception to the warrant requirement just because 5 or more justices of this court happen to believe that such entries are reasonable? or is this exception more directly tied to the law? The answer, I believe, is the latter. From before the founding through the present day, the common law has generally permitted a private citizen to enter another's house and property in order to avert serious physical harm. In those circumstances and many others, courts have historically held that property rights give way to concern for human safety. Courts have long described property law necessity defenses like these as turning to on the adequacy of the defendant's judgment, not a post hoc assessment of necessity in fact. Footnote 1. Contrary to Mr. Case's argument, King v. Coate does not establish that the common law demanded an exacting showing of actual necessity to defeat a claim for trespass. True, Lord Mansfield explained that any necessity defense in that case would need to stand the strictest test with the necessity manifestly proved. But Coate involved an effort to involuntarily confine a person in a madhouse for 2 months, not a claim over a home entry. And it is hardly surprising that the common law would demand a good deal more to justify a serious deprivation of liberty than to excuse an invasion of property rights aimed at protecting human safety. Carrying on. The common law emergency rule is now often summarized this way. One is privileged to enter or remain on land in the possession of another if it is or reasonably appears to be necessary to prevent serious harm to the actor, the other, or a third person, unless the actor knows or has reason to know that the one for whose benefit he enters is unwilling that he shall take such action. But of course, this privilege comes with its logical limitations. So, for example, a private citizen who enters a home to render emergency aid lacks license to do so in a manner which a reasonable man would not regard as necessary to address the apparent emergency. Today's decision echoes both the common law emergency aid rule and its limitations. It does so, to be sure, in the context of a law enforcement officer, not a private citizen, who sought to enter another's home. But on this point as well, the common law has spoken, long providing that officers generally enjoy the same legal privileges as private citizens. And reflecting the common law here again, this court has held that the Fourth Amendment usually permits officers lacking a valid warrant to take actions that any private citizen might do without fear of liability. But they normally may do no more than that. It should come as no surprise that our decision today might accord with the accumulated learning of the common law, just as it should come as no surprise that our application of the Fourth Amendment ought to be informed by the common law's lessons rather than mere intuition. For a period, to be sure, the miasma created by this court's Katz era led some to think the scope of the rights guaranteed by the Fourth Amendment depend on nothing more than current judicial instincts about reasonable expectations of privacy. But that confusion cannot last forever, for no one should think the rights of Americans hang on so thin a thread. Instead, as Justice Story recognized, the Fourth Amendment is made of sturdier stuff, representing the affirmance of a great constitutional doctrine of the common law. And that does it for the opinions in this case. I'm not sure that I have all that much to say about the majority opinion itself, other than it strikes me as correct. I mean, at bottom, the court is pretty much just saying that, hey, the Montana Supreme Court didn't, stick to our precedent. It kind of tried to reconcile its existing doctrine with our precedent, but in doing so, it kind of used terms that we're not all that comfortable with and might confuse things. And what Case is asking for is, definitely not the right standard under our precedent. Our precedent is objectively reasonable basis to believe that, somebody needs immediate aid, and that's what we're sticking with. And I think, I don't know, that's probably a permissible standard under the Fourth Amendment. It does concern me. This case, the Supreme Court's not really deciding in this case, like, whether that standard is permissible under the Fourth Amendment. I think the Supreme Court is mostly, in this case, just saying, this is our precedent, and we're sticking with it. But, Yeah, it's probably a permissible standard under the Fourth Amendment, but it does concern me because it's a fairly permissive or low standard for police officers to enter your home, for agents of the state to enter your home. It's always concerning, from the sort of Fourth Amendment perspective. But the court does go out of its way to mention they can only enter if they have an objectively reasonable basis to believe that somebody is in need of immediate assistance or emergency assistance, whatever. And they can only search the home to the extent reasonable to, deal with that immediate risk of harm and consistent with officer safety and all the rest. But I don't know, it does bother me that you could have police entering somebody's home without a warrant on a relatively low, relatively permissive standard like this, and maybe not search for evidence of a crime, but maybe they happen upon evidence of a crime, and then that is permissible, or that is admissible in court later. It's a little concerning, but I don't know how big a concern it really is, and it might be very, very theoretical or very speculative or very small concern, practically speaking. But yeah, as for the concurrences, I did not like Sotomayor's concurrence at all. It struck me as completely unnecessary, adding almost nothing to the analysis, almost nothing of substance. I feel like what was arguably added by her concurrence could have been summed up in maybe a few sentences instead of 5.5 pages. I also didn't like how she did the citations. Like, you probably noticed several of the footnotes in a row were just citations, and normally that's not the case. Most Supreme Court opinions, they do in-text citations, which normally kind of bother me because it makes the opinions harder to read, but the fact that they do it consistently, means I can kind of develop a practice of skipping over them and, figuring out what I do and don't need to read and whatnot. And, as you probably know by now, I read the footnotes because I think the footnotes can be important. But then when you've got the in-text citations done the normal way, the way the Supreme Court always does, and in footnotes, and also some of the footnotes are actually substantive, like they're actually adding something to the opinion, it's really, really annoying because it's like, well, I need to read some of these footnotes, and I don't just want to be like, footnote 1, and then ignore a bunch of them, and then footnote 6. It's like, well, where did 2 through 5 go? But whatever, that's just a gripe that's mostly a product of what I'm doing here, reading Supreme Court opinions and the way that I do, the fact that I include footnotes, whatever. But yeah, the main critique that I have is just it didn't seem to really add anything. It's just, hey, just because it's reasonable to enter the home of somebody experiencing a mental health crisis in this case doesn't mean it always will be, because mental health crises they're weird and they're unpredictable and very case by case specific and whatever. And she even says, well, the standard that the majority is sticking with is a case-by-case determination. It requires that case-by-case determination, so I join it in full. It's like, okay, so what did you add, right? Just underscoring that you need to do that case-by-case determination? Okay, you could have said that in 1 or 2 sentences, not 5.5 pages. And of course, I did note that she felt the need, me being big Second Amendment gun guy and knowing that Sotomayor is not so much a fan of Second Amendment, or at least the Second Amendment as it's understood in the Supreme Court's precedent today, did note that she felt the need to include that, the fact that nearly 50% of Americans have guns in their homes makes these situations even more dangerous. It's like, cool, great. But Gorsuch's concurrence, on the other hand, consistent with, my general appreciation of Gorsuch and his opinions and whatnot, pretty good. I thought it actually added something helpful or meaningful or of substance going into the actual legal bases for this standard, going through the common law basis for this objectively reasonable basis for believing blah, blah, blah standard. And I found that kind of welcome because it's important that these standards have a real legal basis to them. And, where there's not a basis in the Constitution itself, where it's not spelled out explicitly in the Constitution itself, we kind of do have to look to founding era practices and common law and that kind of stuff and stuff that came before the founding and whatnot. And Gorsuch does that, and that's very helpful because, yeah, where does this come from is an important question. Maybe not one that has to be addressed in this opinion, which is, maybe why it's being addressed by a lone concurrence of Gorsuch's and not by the majority, right? Like the Supreme Court has already developed this standard, this test in a prior case. So maybe in that prior case, they go through the common law basis for it or something. I don't know. But again, welcome in my opinion that Gorsuch went to the trouble to do so here and did so in just 3 pages. Yeah, I think that's about all I have to say about the opinions in this case. So, if I may ask you, my friends on the other side of the screen, please like, share, comment, follow the podcast wherever you follow podcasts, and if you'd like to support the show, you can do so on Patreon. The main content of the show will, of course, always remain free, but Patreon members have access to episodes early and to any bonus or exclusive content, and they can request specific content, including other than reading Supreme Court opinions. With that, tune in for the next episode, where we will continue on through the recently released 2025 term opinions. Till then.